Western Cape High Court having a virtual sitting this afternoon to hear an argument from Public Protector Busisiwe MKhwebane that Parliament is wrong to try and remove her from her position. She's taken Parliament to court after it adopted rules that would govern a process of investigating her fitness to hold office. Her advocate, Pierre de Vos, told judges that Parliament's rules are biased against her and that she would not be fairly treated. MKhwebane said a series of findings that she made overturned by the courts, including personal costs orders against her. Professor Pierre de Vos is a professor of constitutional law at UCT. Prof, good afternoon to you. The Public Protector wants to stop Parliament from considering removing her. What does she have to prove to win this case?
Well, there are two legs to the argument. The one is that the rules that was adopted by Parliament on her insistence, and which sort of tracks the rules that was made for the removal of the President based on the Constitutional Court judgment, that those rules are invalid, unconstitutional. Secondly, she's saying Parliament, or there are some unnamed people in Parliament who are biased, and so it's not possible for Parliament to give her a fair hearing and to decide fairly on whether she should be removed or not.
Okay, I mean, Parliament is full of biased people. That's why we elect them, isn't it?
Yes, so I think the second argument is going to be very difficult, especially to sustain, especially because she hasn't actually identified individuals. When the time comes for the hearing, of course, she can make the argument, but of course this is one of the things with Parliament, as you point out, they are full of politicians. So if that is going to be the rule, Parliament will never be able to have any hearing of any kind, so it's going to be tricky.
Okay, I mean, we are on sort of new ground here, because we never actually looked at this. And I mean, I was amazed to find that Parliament first, I mean, we're going back almost a year now, that Parliament first had to make up rules to govern the process of investigating whether someone is fit for office.
Yes, so but that is the result of the judgment of the Constitutional Court about impeachment of the President. Remember, in that case, the court said that if you have in the Constitution specific criteria for removal, and you can only remove a person for those criteria, you have to have a pre-process first to establish, are there actual factual grounds to say that the Public Protector is guilty of misconduct, incapacitated, or whatever the case might be. And so she argued at the time, I have to have the same rules as the President. This is the Constitutional Court judgment, and then Parliament passed the rules to give effect to this.
Okay, so have I understood you correctly? Are you saying that she's complaining about the rules she wanted?
She's complaining about the rules that she insisted on being made, but she said that the rules that are there are not fair, including the fact that there is not an absolute right to have a legal representation at the very first stage when Parliament decides whether to actually consider the matter at all. So this is a little bit strange because the Constitutional Court in the Zuma case, in the impeachment case, already said that is not necessary, but it is what it is.
Okay. I mean, the idea of someone who holds high office, who's been appointed, I mean, Parliament appoints you. Parliament plays a big role in appointing you. The President sort of signs off. I mean, that would seem to think that the same process must be followed for you to be removed. If you're employed by three people, X, Y, and Z, X, Y, and Z should have the power to remove you. I would have thought that would be a pretty normal policy.
This is not exactly correct, I think, in the sense that these bodies, some institutions like the Public Protector, they have the independence protected, because you can imagine if Parliament can just remove you, anytime the Public Protector makes any decision that is going to go against a powerful person in the majority party, she could be removed. So there are particular protections for the Public Protector and other Chapter 9 office holders to ensure that Parliament doesn't abuse its power and remove somebody from office just for reasons that has nothing to do with their unfitness to hold office.
Okay, I'm with you now. One of the claims that the Public Protector is making is that, one of the arguments that her advocate, Pierre de Vos, is making is about the attitude, the Speaker of Parliament, Thandi Modise, and her attitude to MKhwebane. If I remember the history, the Democratic Alliance first wanted Parliament to investigate her fitness for office. Eventually the Speaker agreed. Does Modise have a lot of power here?
The way the rules are set up, the Speaker has to decide whether to refer the matter, but her discretion in this regard is limited, because if there is any factual basis for the claim, she has to refer the matter. The Constitutional Court has been clear about that in other cases dealing with impeachment and the the vote of no confidence and so on. So there is a discretion, but it's a very limited discretion. So she doesn't necessarily have as much power as Advocate Paul suggests.
Okay, I mean, and just sort of looking forward, we've seen over the last little while that people use every appeal, every legal appeal, every appeal that they have the right to have, they've been using. At the same time, though, the Constitutional Court is, in my view at least, getting a little interesting. It turned down an application for leave to appeal in the Honeycomb case involving former President Jacob Zuma. If you're suggesting the Constitutional Court has already ruled on aspects of this case, it would turn down a leave for appeal there too, because it would say this is settled law.
Yes, if the court thinks that the rules as they stand give effect to the judgment that is made in the impeachment case, the court will not hear the matter because there will be no prospect of success. The only chance would be for the public protectors to convince the court that these rules that were made actually do not actually embody the letter and the spirit of the Constitutional Court judgment in the impeachment case.
Okay. I mean, in so many ways, this case is typical of what we've seen over the last 10 years. Judges being dragged into what, to an extent, are political disputes. I can imagine that the judges probably breathed quite a heavy sigh when they saw this one coming.
Yes, there's been many of these cases. It is, of course, a feature of our politics that what we as lawyers call lawfare happens, where political fights or fights between politicians or political parties are going to the courts. It's not always an ideal thing, but at least what happens if it is done well and with circumspection is that there will then be a final decision, and that hopefully will be slightly diminish the political temperature around these issues, because of course it's also in people's interest to make it into a political case and not into a factual case of whether a person is fit for office or not fit for office.